I hope everyone's mics are working fine. Can we quickly test it if there's any issues? I'm here to help with respect to tech.
Hello, good afternoon.
Yes, hi, good
Good
afternoon.
afternoon.
Good afternoon. Hi, good afternoon.
Is there anyone particularly that we are waiting for? Or can we get started?
Hi, we are waiting for the judges, two of them.
Okay, can you specifically tell me the names?
Names?
Yes, one of them
One
is
of them is
Aditya Singh Chauhan, and the other one is Kareem. So
No,
I don't.
Kareem is here.
Oh yeah, hi.
Hi.
Yeah, so Aditya Singh Chauhan only.
Uh, is it possible that you can forward a message to Aditya, or should I try doing it?
Let me see. I think we do have his email, so but yeah, but he can only log in through like the links of meetings specifically.
Okay, I'll see what
Yeah.
I can do. Hi everyone. I think Aditya Singh Chauhan has just joined. Um, is that right?
Yes, just give me 1 minute. Let me set up my.
No worries, Aditya.
Just give me 1 minute. Hi, can you hear me? Hello. Am I audible?
Yes, Aditya, you're audible. I would request everyone to accordingly turn on their cameras to begin. Aditya, you can take over. And Ryan, yeah, you can take over.
Let me just
Sorry, Aditya and
Who's
Kareem.
from which
Right.
team? Yeah. Okay, so today I'm with Kareem and Alex. Have okay. Kareem is here. Alex is here. I think there's one more judge.
Yeah, I'm replacing Alex. He's not going to be with us today.
Okay, great. Hi, hi.
Hi.
Okay.
Okay, so we're doing it between Middlesex University Dubai Team 1 and University of Sharjah. Can the participants please kindly put their names and what are they representing onto the chat box and how much time is dedicated to each council? Thank you. Okay, let's just confirm if both the councils are here for both teams. Middlesex University Dubai 1, are both councils present?
Yes, both
Yes.
of them are present.
Okay. And for University of Sharjah, are both councils present?
Yes, represent.
Okay, perfect. Thank you. So let's begin. Let's begin. Yes, 1 second. Give me a minute. Okay. So let's start with the senior claimant. You have the floor.
Um, just before we begin, can I confirm if the court has the claimant's bundle with them?
Yes, we do.
Yes, we
Okay,
do.
thank you. Thank you. May I start?
Yes, you may.
Good afternoon. May it please the court. I am Ryan, the senior counsel for the claimant, along with my co-counsel Sarah Jamshad. The counsel is appearing before the Honorable Court in the matter of Ms. Artemis Astrothea and Solar Dream Incorporation on behalf of the claimant under the DIFC Court of Space. Would Your Honor benefit from the key facts of the case?
Yes.
Yes, please.
The facts of the case here are the claimant, a famous YouTuber known for her Astro Yoga channel, bought a 10 million US dollars worth ticket for the defendant's Star Alliance spaceflight retreat. She hoped that this retreat's promise of enhancing the life force would cure her chronic headache. However, she failed to disclose her headache during the medical evaluation and checkups out of the fear of being barred from the retreat. Subsequently, on the day of the flight, she was suffering from a headache but failed to disclose it due to the significant investment she had made. Moreover, on the day of the launch, despite a delay in receiving the PCR test, which were initiated in light of the COVID variant outbreak, the flight proceeded with the lateral flow test results because of the meteorological conditions leading to the launch window to close. However, shortly after the launch, it was discovered that the claimant tested positive for COVID-19, leading to all passengers and crew members contracting the virus and an early return of the flight to the Earth. Your Honor, today we seek restitution for the claimant due to the defendant's negligence and subsequent breach of contract, entitling the claimant to $15 million for the losses she has suffered and the gain she was deprived of as a result of the defendant's conduct. I will be dealing with the first round of the proceedings and will be speaking for 18 minutes, and my co counsel will be dealing with the second round and will be speaking for 17 minutes, respectfully reserving 10 minutes for the rebuttals. I will be covering three main issues today. Firstly, the defendant's failure to exercise reasonable care, causing harm to the claimant. Secondly, the defendant's breach of contract in failing to deliver the services the claimant had paid for. And thirdly, the claim for loss of earnings resulting from the claimant's inability to film the highly anticipated and advertised space yoga sessions. May I begin with my first submission, Your Honors?
Yes, please.
Thank you, Your Honors. My first submission concerns the defendant's failure to ensure the safety and well being of its passengers, including the claimant, by not following proper medical evaluation procedures and thereby being negligent. Under Article 17 of the DIFC Laws of Obligations, there are three conditions to establish negligence liability. The first condition, according to Article 17, Subarticle 1A of the DIFC Laws of Obligation, is that the defendant must owe a duty of care to the claimant. This duty of care is further illustrated in Article 18 of the DIFC Laws of Obligation, which establishes that a duty of care exists where it is foreseeable, where there is a sufficiently proximate relationship between the parties, and it is fair and just to impose such a duty on the defendant. Here, the Council contends that there exists a duty between the defendant, Solar Dream Incorporation, and the claimant, Ms. Artemis Astrothea. As parties to the contract, it is reasonably foreseeable that a sufficiently proximate relationship exists between them, and given the considerable money involved in the contract, it is fair and just to impose such a duty on the defendant. Additionally, it can be seen that this provision of the DIFC Laws of Obligation is based on Article 5.1.4, Subarticle 1 of UNIDROIT Principles on International Commercial Contracts 2016. This article provides that, to the extent an obligation of a party involves a duty to achieve a specific result, that party is bound to achieve that result. The subsequent commentary clarifies that the nature of the duty of care in this case is that which raises the duty of the defendant to achieve the specific purpose of providing the agreed service, which includes the solar powered meditation and yoga sessions in space, within the agreed time to the claimant. This highlights that there is a high standard of duty of care owed by the defendant to the claimant. Subsequently, the second condition, according to Article 17, Subarticle 1b of the DIFC Laws of Obligation, is that the defendant breaches his duty of care to the claimant. Your Honors, the fact here indicates that the defendant has breached its duty of care to the claimant in two ways. Firstly, the defendant failed to comply with Article 6, Subarticle 1J of the UAE Regulation on Human Spaceflight 2022, which requires the spaceflight operator to provide evidence that participants are medically fit to participate in the trip. However, here, by launching the flight before receiving the PCR test results, the defendant has failed to ensure that participants were fit as per the required regulations. Secondly, the defendant has failed to comply with Section 4.4.4 of the Recommended Practices for Human Spaceflight Occupant Safety 2023, which requires identifying medical conditions that could result in the flight ending early and taking necessary steps to mitigate these risks. Here,
Counsel, if I may, I just have a
yes.
question for you. Now, what are the symptoms of this variant? I'm assuming that it includes a chronic headache, and as a result, your client who's claiming these damages, first, your client had chronic headaches, and in fear of not disclosing it, when the pre-medical checkups were happening, your client concealed the symptoms when the initial test was taken. Do you think that there is a possibility that if she had disclosed the symptoms beforehand, which is a symptom of this particular variant, then the test results may be different. So in a way, your client was at fault for not disclosing the symptoms.
Your Honor, the fault of my client's non-disclosure will be discussed by my junior counsel. However, I would like to say that even if the claimant had disclosed her headache, they should have, if did whether they did or they did not, the defendants should have waited for the PCR test to return until they made sure that every passengers were fit to fly, and then set out for the launch, Your Honor.
Consul, is it the case that the passengers were not made aware of the fact that the PCR test results are not out?
Yes, Your Honor. No, Your Honor, the passengers were aware that the PCR results were not out. There was a delay. However, the nurse that is part of the medical defendant's medical team had said that it would be statistically impossible for the PCR test to return positive.
Was it statistically impossible or statistically improbable?
Improbable, Your Honor.
Please continue.
Secondly, okay, sorry. Therefore, these non-compliances highlights the fact that the defendants have fallen below the industrial standards and thus risking the life of the passengers and the crew. Furthermore, the comparison study between the efficiency of PCR and the LFTs reported in DUF Press, which can be found on page 19 on the claimant's bundle, shows that the PCR tests are more reliable, especially when it comes to individuals who are not at their peak transmissible stage of their infection. Moreover, inconsistencies such as a negative LFT and a positive PCR in this case may also occur due to inadequate swab collection or testing procedures. These inconsistencies offer underscore the importance of having a highly qualified medical personnel conduct the evaluations and make informed decisions. However, in this case, the nurse's reliance solely on the LFT results without waiting for the more accurate PCR test demonstrates a lack of proper medical oversight and expertise. This can also be highlighted by the fact that the nurse was not qualified in aerospace. This failure to follow appropriate protocols and ensure the safety of the participants before the spaceflight represents the breach of the defendant's duty to provide a sufficient and qualified medical team for such a significant investment project. Therefore, I request the court to consider the defendant's conduct which shows that the medical evaluation and oversight of the space flight fall short of the reasonable standard expected from the defendant according to Article 21 of the DIFC Laws of Obligations, indicating a breach of their duty to ensure the safety and well-being of the passengers, including the claimant. Moving on, the third condition, according to Article 17, Subarticle 1C of the DIFC Laws of Obligation, provides that the defendant's acts or omissions in breach of his duty of care to the claimant should cause a loss to the claimant. According to a report by PubMed, it shows the possibility that these COVID viruses might be dormant and an LFT might not be able to detect these dormant viruses, instead, often requires PCRs. In such a situation, it suggests that by exposing such dormant virus carriers to space, it might lead to activating the viruses, causing harm to the claimant. Here, the counsel argues that the claimant's initial headache could be attributed to her chronic headache, as that was the only symptom seen in the claimant, apart from the fatigue which could have been resulting from the traveling. However, by exposing her COVID virus to space, as identified from the PCR, the defendant has led the viruses to activate, causing her harm. Here, upon reaching the yoga mat, the shuttle, it can be seen that her condition worsened where she was too unwell to undertake any meditation or yoga even on her own or to film the videos she had advertised. Moreover, Your Honor, if had the defendant timely identified the claimant as a COVID virus carrier while she was on Earth, she would have received proper medical attention and rescheduled the flights, which would have prevented the loss of her opportunity to record the space videos. Thus, although not the sole cause, the defendant has contributed to the loss of the claimant, thereby establishing a link between the breach and the harm caused. Hence, the defendant's failure to follow proper medical evaluation procedures and take appropriate measures to prevent the spread of the virus resulted in the premature return of the spaceflight. Therefore, the Council condemns that the defendant has been negligent under Article 17 of the DIFC Laws of Obligation by breaching its duty of care to the claimant who has relied on them and made a considerable investment, causing harm to the claimant. And that concludes my
Consul,
first submission.
I just have one question with regards to this. if we say we are talking about loss of revenue, loss of income, we are not talking about these things in cases of, say, a personal injury, permanent injury, any sort of injury or death or disablement. We are talking about simply in terms of the lost opportunity. And this
Yes,
is you publishing your client publishing the video and then maybe getting subscription. What obligation does the company have in order to take into consideration all of these things? And on top of that, how is it not remote? How can we assign any sort of a monetary value, uh, the value that you have claimed in such a scenario?
I believe, Your Honor, I will be discussing this in my third submission.
Please continue.
May I continue with my second submission, Your Honor?
Yes, please.
Thank you, Your Honor. My second submission concerns the failure of the defendant to provide a service they have promised under the contract. Under Article 77 of the DIFC Laws of Contract provides that non-performance is a failure by a party to perform any one or more of its obligation under the contract, including the defective performance or a late performance. Your Honors, here, the defendant has breached the service supply of service contract between the claimant as per the agreement entered on 10th December 2023, which promised a unique opportunity for a solar-powered meditation and yoga session in space, which aimed at enhancing life force energy. However, despite the defendant's launch on 15 January 2024, the claimant's quarantine due to the COVID-19 infection prevented her from actively participating in the retreat, where I would like to reiterate from my first submission that a timely identification of the virus would have prevented the claimant's losses, Your Honor. The council argues that this constitutes a defective performance of the contract. That is, while physically being present on the spaceship during the journey, she was deprived of the intended service experience, which includes the yoga sessions. Therefore, they are to be held liable, the defendants are to be held liable for non-performance of contract, and subsequently the claimant asked this court for a refund of amount of $7.5 million that was paid for the services as per the agreed installment plan for the services which was defectively delivered. And that concludes my second submission, Your Honor. With your permission, I would like to proceed to my third submission.
Yes, please do.
Thank you. My third submission concerns the $7.5 million losses for loss of earnings attributed to the defendant's negligence and the failure to fulfill the contractual obligations. According to Article 20 of the DIFC Laws of Obligation, the claimant is entitled to seek compensation for pure economic losses arising from the defendant's negligence, given that the defendant assumes a responsibility to the claimant relies on the defendant, and it is reasonable for the claimant to rely on the defendant. Here, the claimant, after her long discussion with the defendant's representative, enters into the contract where the defendant knew what the claimant was bound to achieve from it, which includes curing her headache and the YouTube videos, Your Honor, and in fact was aware of the possibility that she would not be able to achieve her objective while entering into the contract. This shows that the defendant assumed responsibility to the claimant. And given the contract and the considerable investment made under it, it was reasonable for the claimant to rely on the contract with the defendant. Further, Your Honor, to substantiate the loss of earnings and estimates of a potential revenue that could have been generated from producing and sharing the space yoga content on the claimant's YouTube channel can be considered using factors such as the claimant's 27.3 million subscriber base, which indicates that a strong audience that is interested in her content and would likely engage with her space yoga videos. Moreover, similar space videos such as Dude Perfect Goes to Space with 37 million views per year have proved to generate high profits, and therefore the claimant reasonably believes that if the content was well produced and engaging, it would likely attract a larger audience and generate more
Counsel,
revenue.
I understand that the claimant reasonably believes that, but is it reasonable for the respondent to have an accurate knowledge of your client's subscriber base and what the purpose for which they are entering into this entire space flight? Because what it is advertised at and for what they are providing these services and the contract that has been entered into, it's simply for space tourism, and it is not for any person to sort of commercialize it. So why is it an obligation on the respondent?
Yes, Your Honor. However, with the long discussion with the sales representative of the defendant, the claimant has mentioned that this trip would aim to cure her headache, and that she intends to take YouTube videos, which she is posting on her YouTube channel. And from the facts, it could be inferred that the defendants were aware that she was a high net worth individual.
No, no. So, counsel, my question is the agreement is the sum and substance of the entire understanding. It is an entire agreement, and nothing beyond that is something that we are concerned with. So, whatever discussions which may have happened with sales representatives, uh, as far as I'm concerned, I don't see a reason to look into that. So, please tell me why I should say that it is reasonable for the respondent to have knowledge of the claimant subscriber base, based on which you're claiming your particular claim that you've made under the law of obligations.
Um, Your Honor, can you please rephrase your question again?
Why should the respondent consider it reasonable, uh, considering everything I just said, to look into your client's subscriber base and what revenue it generates in order to compensate your client for whatever claims you've made today?
Firstly, Your Honor, I would like to reiterate that this claim is taken under Article 20 of the DIFC Laws of Obligation, and as a pure economic loss, which is arise from a negligence, which means that the damages are not agreed upon by the parties in the contract. So I I do reiterate that the discussion with the representative stays as the ground for claiming this loss of earnings.
You please continue.
Thank you, Your Honor. Therefore, the council argues that these losses must be considered as pure economic losses. And the claimant additionally also argues that there was a substantial loss of existing subscribers who were anticipating the space-related content and were disappointed because of the unposted content, which directly impacted her potential earnings. This claim can also be supported by Article 110 of the DIFC Laws of
Apologies,
Contract.
counsel, your time is up. So can you please conclude your submissions in 1 minute?
Yes, Your Honor.
Thank you.
Therefore, the Council respectfully urges the Court to thoroughly evaluate the submissions and facts presented in this case and rule in favor of the claimant. The claimant is thus seeking a full compensation of 15 million US dollars, which includes 7.5 million US dollars as the refund from the contract and 7.5 additional losses for loss of earnings. And that concludes my submissions, Your Honor. Thank you.
Thank you, counsel. Uh, do any of the judges have any questions for the counsel, or should we proceed to the senior claimant,
No
sorry,
questions from me.
senior defendant? Thank you. Okay, let's move to the senior defendant. Senior defendant from University of Sharjah.
Hello, guys. Could you see me?
Yes,
Your
we
Honor?
can.
Shall I
Yes,
proceed? Shall I begin?
please do.
Okay.
Please do.
Members of the esteemed court, distinguished advisors, honorable audience, my name is Hissa Ahmed, and along with my co-counsel Hind Mohammed, we are representing the defendant party that fulfills the applications and falls on Artemis Astrothia, the passengers, on a contract that was signed between both parties on December 13, 2023. So basically, Solid Dream leading the way in a space travel includes and invites adventurers on incredible journeys into space with 4 successful flights, each carrying 10 brave passengers. Solid Dream had sparked the imagination of those space adventurers behind their efforts in celestial habit, ensuring a very smooth travel in space, in the outer space. As the Moon Gateway gets ready to reveal its secrets, Solid Dream heads toward lunar exploration and a new era in space travel, that's just the start. Having amazing experience with Solid Dream special space retreats. Picture the Sign Alliance yoga retreat made for adventure souls. Imagine being taken on the space yoga mat as an actor in the vast floating heaven, collaborating with the Emirates Space Lines as well. The luxury sanctuary mixes luxury with the thrill of discovery. Solid Dream's partnership with the Emirates Space Lines and Celestial Habits mark a new age of space exploration where the stars calls and adventures awaits. Join Solid Dream as we push the boundaries of human discovery and embark on an affordable journey into space. Your honor to seek your notice on the relevant facts as well. Basically, Solidream, it's a Canadian space flight company, provides a high net worth for a specific passengers on the space yoga. It operates spacecraft with 10 passengers each and 20 employees on ground as well. Supervised by astronauts and ground staff, supported by celestial habits to ensure that the space travel will be so smooth for maintenance and surviving. Plan to expand flights to the moon gateway as well. The passenger Artemis Astrothia, she's a 27-year-old YouTuber with a successful channel focused on yoga and travels. She suffers from a chronic headaches 5 years period and believes space yoga could elevate them actually. Solid Dream offered them space flight retreats. This year retreat is a space yoga in the outer space, involved a space yoga experience on the Space Yoga Mint, part of the Floating Heaven space station operated by the Emirates Space Line. Artemis purchased the air ticket for the Stars Aligned retreat, participating or anticipating a need video that will be uploaded in her YouTube channel, although she's very famous in her YouTube. 2 days after purchasing the ticket, Artemis underwent a medical evaluation by the Solid Dream team for the preparations of the trip as well. So there is a contractor relationship between Artemis Astrothia and the Solid Dream. Artemis quarantines in Dubai before the trip, even the rules of operations and the medical teams as well. There is a disease which called a volcano, similar to the COVID-19, which is spread before the space trip as well, which usually spread and poses a risk to the trip. Passengers undergo medical tests before flight due to the COVID-19 variant. Artemis PCR test is delayed, but she's allowed to board based on the negative later flu test because the Solid Dream Canadian space flight need to be on time. They don't want to waste time just waiting for the PCR. Although the PCR test after 2023, 2024 during the space flight, it wasn't mandatory to make a space flight, or sorry, for the PCR tests. All passengers on crew on the space yogament contracted COVID-19, leading to an early return to the Earth. Artemis' symptoms worsened upon arrival, preventing her from participating in the activities. Your Honor, moving on the issues actually, Solid Dream filed a counterclaim seeking 5 million in damages, alleging that Artemis, who had on her YouTube channel, basically Artemis Astrothia, she hid her symptoms. She was suffering from a chronic headaches 5 years period, and she breached the contract. She didn't mention for the Solid Dream team about her headache, and she also uploaded a video on her YouTube channel causing a reputational loss for the Solid Dream team, which lets the other passengers canceling their reservations for the future space flight as well. Basically, failing to declare the
Council,
medical.
just one question I have for you. Whatever the claimant has posted on her YouTube channel, was there anything contained which was false?
Come again, Honor?
Was there anything contained which was false?
Basically, Artemis Astrothia, she's a very wide YouTuber channel. She posted a video that she couldn't post a video going to space yoga as she promised her subscribers. She's very famous in the YouTube, so she couldn't actually upload a video. So she caused a reputation loss for the Solid Dream. Other passengers, they canceled their reservation for the future. So yeah.
No, but whatever the claimant posted, or whatever the claimant published for that matter, was it not the truth? What actually happened? And was there any obligation of confidentiality on the claimant?
Actually, if Artemis Astrothia, perhaps if she did mention her headache before being on board, Solidary will take more safety measures and protocols. Like, even she doesn't have the right to seek the compensation she's asking for. She's having 15 million dirhams. She's $15 million, sorry, from the court. She doesn't have the right because she infected other passengers as well. And she caused even a reputational loss for the Solid Dream Canadian space flight. And according to the other passengers, they canceled their reservations, and she suffered a very reputational loss for the Canadian space flight.
Counsel, so your counterclaim is for how much?
5 million.
5 million, and that 5 million is basis what grounds?
The 5 million, because she hid her symptoms. She was suffering from a headache chronic 5 years period, and she didn't mention that. She breached the contract, actually, and she caused a reputational lose for the Solid Dream team as well in uploading a video because she couldn't do she couldn't post a video for her space yoga and her YouTube channel as well.
So is this for a breach of contract, or is this for loss of reputation?
Both of them, breach of contract and reputational lose as well.
Understood. And let us just come to the reputational loss.
Yeah.
In terms of reputational loss, what I'm asking is whatever the claimant posted, right? In just one sentence, just let me know, was it the truth or do you dispute that it was the truth?
Is it it is the truth, but she hid her symptoms. Like for that time during 2023, 2024, PCR test was not mandatory. And the Canadian space flight was need to be on time to travel on the space flight as well. So although she did post a video causing reputational loss and other passengers canceling their reservations as well, but this has caused a very reputation. We may reschedule her space flight another time or maybe refund her money another back.
Got it. Thank you.
Okay, shall I proceed, Your Honor?
Yes, yes.
Okay. So, Mrs. Astrothia, liability to Solid Dream on breach of contract. Under Clause 5 of the Space Flight Agreement, Ms. Astrothia had a clear contractor relationship due to school any medical condition that could affect her fitness to participate in the space flight. Despite suffering from a chronic headaches 5-year period, Ms. Astrothia internationally failed to disclose this medical condition to Solid Dream during the medical evaluation process. If Solid Dream had been aware of Miss Astrothia and disclosed a medical condition, she would not be permitted to participate in the retreat as well. Pursuant to the clause 5.4 of the agreement, she breached the contract and she caused also the reputational loss for Solid Dream. And Your Honor, we are proceeding now to the arguments. Clause 5 contains medical disclosure obligations to Ms. Astrothia only. It seems the Clause 5 of the agreement between Solid Dream and Ms. Astrothia likely contains medical disclosure obligations. The counterclaim filed by Solid Dream alleges that Ms. Artemis Astrothia breaching the agreement by failing to declare her medical condition. Clause 5 likely explicitly states that both parties are obligated to disclose any medical conditions that may affect their ability to fulfill the terms of agreement. By failing to disclose her pre-departure headaches, Ms. Astrothia violated this requirement, and according that she signed a contractor relationship before being on board, so she breached the agreement as well. The agreement may specify that any medical condition that could reasonably be expected to impact the performance of the agreement must be disclosed. Pre-departure headaches observed or recurring could potentially fall under this category, as they may affect Ms. Astroth's ability to participate fully in the retreat, in the space yoga. The agreement may include provisions related to safety and risk management by not disclosing her medical.
Can I just please ask you just to speak a little bit slower?
Okay, sorry
Thank
about
you.
that. The agreement may include provisions related to safety and risk management by not disclosing her medical conditions. Ms. Astrothia potentially increased the risk to herself and others during the retreat, which could be considered a violation of the agreement's safety protocols. Non-disclosure of a medical condition could have financial implications for both parties. In this case, the cancellations of the retreat and subsequent reputational damage led to financial loss for Solid Dream, as we said previously. By failing to disclose her condition, Ms. Astrothia may have contracted these losses, those breaching her obligations under Clause 5.
Apologies, counsel. I just have a question. Like before, what kind of safety protocols were actually taken by Solar Dream before taking off the flight?
Before being on board,
Yes.
yes, we did a medical evaluations by the team of the Solid Dream Canadian Space Flight to see fitness of the passenger itself. But for the COVID-19 and PCR test during that time, it wasn't mandatory to make some COVID-19, so we didn't wait for her PCR test as well.
Yeah, but just relying on LFTs, which is also a result which gives false information, was that not risk taking by Solar Dream?
Come again, can you repeat your questions? Sorry about that.
Yes. What I mean is, isn't the Solar Team taking a very major risk by just relying on LFT results, which does give like wrong information and false
Actually,
results?
yeah.
Yeah, please.
Basically, in this, I can say that Artemis Astrothia, when she didn't mention her symptoms, actually, it's a very risk for leading to infect other passengers on board. Like Solid Dreams, they take all the safety measures to include that those passengers will be in a safe risk, so they don't infect others as well. So they did the PCR test, including the other 9 passengers. Their result was published instead her. So when the result of her was published on board, they got back on the earth because she have a positive, and actually other passengers infected also, like positive result. She infected other passengers, so the responsibility of Artemis Astrosi as well in this case. Yeah.
Thank you, Counsel. Please proceed.
Okay. She breached this by failing to declare her headaches. She breached the contract in clause 5.2, 5.3 by failing to declare her headache symptoms. Otherwise, the space flight operator wouldn't cancel the trip and avoid any of this situation. And we can add the clause 4 of the contract mentioned that the passenger should be aware of possibility of enforcing event, a risk, and certain risk would remain unavoidable. Moreover, she doesn't have the right to have the compensation she's asking for her illness got worse from her by not declaring her headache earlier when she was under medical examination to prepare her for the flight and cause she infected other passengers, as we said previously. Forwarding this impact flight safety, causing reputational damage for subsequent passengers' cancellations as well.
Counsel, just one question over here. You talk about the claimant having consented to unforeseen risk. Now, what I want to ask is this really unforeseen risk when all the news regarding the variant was present and in fact a test was done, although it was not a determinative test. Now, when this test was done, one, proper security procedures were not followed. What I want to first point in this is the nurse really competent to comment on which test should or should not be followed? And even the nurse's determination was not that she only said that it is statistically improbable. So it wasn't an unavoidable, unforeseen event, but an event created by your decision, which was to you at the time, it seemed to you more commercially feasible. Am I wrong, or would you dispute that? Counsel, you're muted.
Sorry for that, Your Honor. Being on like before being on board Artemis Astrothia, as she signed a contractor relationship with the Solid Dream, she needs to make a medical evaluation and to be with the nurse. So she needs to inform her about her symptoms. Actually, she did declare that she didn't mention any of her headache, so she breached the contract as well as we said previously. So as well as she infected other passengers on board. So yeah,
No, my point was simply with respect to your contention that the claimant has consented to the risk involved in such an a venture, and second, that this particular event was an unforeseen event. My contention was only my point was only with respect to these 2 points.
yeah. Um, can you repeat the first question, Your Honor?
Okay, one, you stated that the claimant has consented to the risk, and second, that it is an unforeseen event. My point is that this is not the risk that the claimant consented to, because this was an avoidable event which occurred not as an unforeseen event, but as a result of a commercial decision which you took because you deemed it more commercially feasible. And I want you to dispute that. I want you to tell me why you say that this is not the case.
Um, Actually, Artemis Astrothia, she's liable and doesn't mention her headache and she's suffering from a chronic because it's a very risk to be on board and she's suffering from it. Even if she's suffering from headache 5 years prior, she infected also other passengers as well. It's a very risk going on board and she's suffering from a headache. Perhaps it's symptoms of COVID-19, even though if the COVID-19 at that time wasn't mandatory to make PCR tests as well.
Can I just ask a question here? Could it be said that that the defendant took it upon themselves to took the responsibility upon themselves to test passengers for COVID, and isn't it the case that the flight was cancelled as a result of um, the flight was belatedly cancelled as a result of the defendant not waiting for the results to come back before takeoff?
Actually, it was the responsibility of Artemis Astrodia. If she mentioned her headache, before being on board, perhaps the Solidarium will take more safety measures
Mhm.
to excluding her from to being on board.
So those safety measures, for example, may have included taking or testing passengers for COVID, for example.
Actually, on that time, during the space flight in 2023, 2024,
Mm.
the PCR test wasn't mandatory. So Solidarium was not liable, or they want to be on time. So they had that time to wait for the PCR test for Artemis
But
astronauts.
if Artemis did disclose her headache, what steps could you have taken?
We may reschedule her flight another time or refund her money back at the same time. Yeah.
Okay, thank you.
Shall I
Yes, please.
proceed, Your Honor? And flight safety incident can cause reputational damage and passenger cancellation. These incidents can cause near misses, safety violations, precise mishandling, negativity publicity, and flight operators to crew errors. Safety incidents can raise concern about the space flight safety protocols, while violations can erode trust in the commitment to safety. Indicant response during crisis can damage the space flight reputation, leading to cancellations as other passengers cancel their future reservations as well. Space operator or the crew errors can erode passengers' confidence, causing further cancellations. The companies lose of profits of next year booking cancellations were after her wide publicity in her YouTube channel, as she is very famous on YouTube. And defamations of companies' reputation are not because of company safety protocols as well. And for now, my co-counsel is Hind Mohammed. She will proceed the relevant laws and articles. Thank you so much. There is any questions, Your Honor?
None from my side.
Thank you so
Okay,
much.
so yeah, if there are none, can we just move to the rebuttals? First, from the senior claimant.
Yes, Your Honor. Firstly, I would like to address the submission about the claimant's fault in the COVID outbreak made by the defendants. So here, if the claimant was identified COVID-19 positive 1 hour after the launch, where the defendant could have waited or rescheduled the flights because of the meteorological condition, as per clause 1.2 of the contract. Instead, the defendant chose to launch the flight, risking the life of the participants, including the claimant. I repeat, risking the life of the claimant and the other passengers by relying on the nurse. Thus, the council reiterates that the defendant has fallen below the industrial standard by considering their commercial interest over the participants' safety. Subsequently, the Subsequently, the situation here should not be considered as an unforeseen event, especially when the COVID situation was not an unprecedented one, and given that they were fully aware of the situation as the cursory examination were conducted in this light. Thus, the claimant asked the court to consider these events as a result of the defendant's negligence. That's all, Your Honor.
Okay, thank you, counsel. Do any of the judges have any questions for the counsel? No. Okay. Let's proceed with the senior defendant with her rebuttal.
Okay. Why did the Artemis hide her symptoms? Perhaps if she did mention her symptoms from a headache, since 5 years period, the Solidarium company will take more safety measures and protocols, so she won't be able to be on board after being on board if she had mentioned her headache. They may reschedule her space flight as well to another time or taking her money back as well. She doesn't have the right of compensation 15 million dirham. She's asking for Helena's got worse from her on affecting other passengers as well on board. She even posted a video on YouTube coming a reputational lose of Solidarium, by which other passengers they cancelled their reservations for future space flight. Moreover, talking badly about Solidarium due that she didn't make space yoga and not uploading a video including the space yoga and flight as well. So she doesn't have the right to ask the compensation she's asking for. Yeah.
Okay, thank you, counsel. We don't have any questions at this point from the judges. Okay. So let's proceed with the junior defendant.
May it please the court. Good afternoon, members of the court. May I proceed, please?
Yes, please do.
I would like to highlight to you the relevant laws and articles to be applied in the counterclaim according to the DIFC articles, which includes the medical evaluation. Firstly, according to Clause 5.1, the passenger agrees to undergo a medical evaluation conducted by a qualified medical professional designated in the spaceflight operator to determine their fitness for space travel. The evaluation may include, but is not limited to, a review of the passenger's medical history, physical examination, and any additional tests deemed necessary by the medical professional. Secondly, the passenger declares and represents that, to the best of their knowledge and belief, that they are not aware of any medical conditions or symptoms of a potential medical condition that may affect their fitness to participate in the spaceflight. The passenger further acknowledges the importance of providing accurate and complete information during the medical evaluation. Thirdly, the passenger undertakes to promptly inform the spaceflight operator if there is any changes in their medical condition or if they become aware of any medical symptoms that may affect their fitness for space travel. This includes any changes that occur between the time of the initial medical evaluation and the scheduled launch date. Fourthly, in the event of a change in the passenger's medical condition that, in the reasonable opinion of the spaceflight operator, may affect their ability to safely participate in the spaceflight, the spaceflight operator reserves the right to deny boarding to the passenger subject to Clause 3.3 above. Fifthly, the passenger acknowledged that they bear no responsibility for promptly reporting any changes in their medical condition in the spaceflight operator, and that failure to do so may impact their eligibility to participate in the spaceflight. And lastly, the medical information obtained during the evaluation process will be treated with the utmost confidentiality by the spaceflight operator in compliance with applicable privacy and laws and regulations. In addition to another relevant law in the article that can be applied in the counterclaim, and in accordance with the DIFC articles, is that of cancellation, which 3.1 states the passenger may at its discretion and by written notice terminate this agreement at any time prior to the launch date. In the event of such cancellation, the passenger forfeits unconditionally any payment already made or due and payable under Clause 2.2 of this agreement. The next article discusses such as that 3.2 states the spaceflight operator retains the right to cancel the spaceflight at any point made under the clause of 2.2. The next article states, in the event of a cancellation by either party, the parties will undertake reasonable efforts to reschedule the spaceflight to a mutually agreeable date. Any rescheduled spaceflight shall be subject to availability in the terms of this agreement. In conclusion, we may also discuss the list of cases that are related and as we're to what we have in today, according to Solar Dream versus Artemis Astrothea. We can talk about a case that is called Allied Van Lines Incorporate versus Bratton in 1991. A moving company damaged household goods during a relocation. The court upheld the company liability for breach of contract and negligence, such as what happened with Artemis, in where she hid her symptoms, and the cause of negligence has happened from her side. And another case can be called as Landry Langston Restaurant Bar. An employment contract was breached involving the end of service entitlement owed to the claimant, who was employed at the defendant's company, Langston Restaurant and Bar, as a due to him being away from UAE due to visa issues at the time he was handed his letter of confirmation. And again, passes off negligence. I can now, in conclusion, what my co-counsel and I would like to bring to your attention is that Solar Dream, as the defendant in this case, seeks just compensation for the damages incurred as a result of Artemis Astrothea's actions. The evidence presented clearly demonstrates the causal link between Artemis's non-disclosure of her medical condition and the adverse consequences suffered by Solar Dream, totaling $5 million, the reputational and financial loss that has been happened, uh, that was caused by the hardships experienced by our client are direct consequences of Artemis Astrothea's breach of contract and negligence. Therefore, we implore this court to carefully consider the evidence and rule in favor of Solar Dream, ensuring that justice is served and appropriate remedies are granted for our client. Your Honor and your esteemed members of the court, the claim put forth by Artemis for $15 million in damages lacks both legal merit and factual basis. Solar Dream, the defendant in this case, bears no responsibility for the alleged harm suffered by Artemis, her failure to disclose crucial medical information, and subsequent breach of the contract are the root causes of the contract loss, of the unfortunate event caused during the spaceflight retreat. Thereby, we urge you to reject the counterclaims presented by Artemis seeking $15 million. Thank you, Your Honor, for your time and the platform.
Thank you, counsel. Do any of the judges have any questions? None? Okay, let's proceed with this junior claimant. Thank you.
Thank you, Your Honors. May it please the court, as has already been indicated by the senior claimant, Ms. Ryan Hamid, my name is Ms. Sarah Jumshed, and I appear on this case as the junior counsel for the claimant, Ms. Artemis Astrothea. Your Honors, I shall be dealing with the second issue in the proceedings, which is that the claimant, Ms. Astrothea, is not liable to the defendant, Solar Dream Incorporation, neither for breach of contract, for failing to declare her medical condition, nor for the commercial reputational harm suffered by Solar Dream. Your Honors, I have 3 submissions to make. Firstly, the claimant has not breached the agreement by failing to declare a medical condition, as the non-disclosure does not amount to a fundamental non-performance strictly required under the agreement. Secondly, the claimant cannot be held liable for breach of contract, as she had acted not only relying on the defendant's misrepresentation, but also because she had already made a significant investment that she would be unable to recuperate. Thirdly, the claimant is not liable for the commercial reputational harm suffered by Solar Dream, as she reserved the right to document and publish her experience for the sake of public interest, and because it was not her statement that had caused the reputational damage. Your Honors, if I may begin with my first submission.
Yes, please do.
I submit that the claimant has not breached the agreement by failing to declare a medical condition, as the non-disclosure does not amount to a fundamental non-performance strictly required under the agreement. According to Article 86 of the DIFC contract law, fundamental non-performance is only when there is an obligation to perform under the contract. Such a failure to perform a contractual obligation is a fundamental non-performance in 4 types of circumstances, which are when it substantially deprives the aggrieved party of what it was entitled to expect under the contract, if strict compliance with performing the obligation was of the essence under the contract, if the non-performance was intentional or reckless, or if the non-performance gave the aggrieved party reason to believe that it cannot rely on the other party's future performance. Although Article 86 relates to fundamental non-performance when it comes to terminating a contract, it was confirmed in the case of Yusuf Issa Ward and Damac Park Towers Company Limited from 2014 from the DIFC Court of First Instance's first judgment of 2015. Would Your Honors benefit from the facts of the case?
Yes, please.
Mr. Ward, in this case, had signed a reservation agreement on October 2009 for the off-plan purchase of a commercial unit in the Park Towers development within the DIFC, costing over 4 million dirhams. Prior to agreement for off-plan properties with Damac Star Properties resulted in arrears, and after the cancellation of that development, a credit agreement was reached to transfer the paid amount to property within Park Towers. Despite negotiating revised payment plans and making further payments totaling over 2 million dirhams, the defendant issued termination notices and eventually canceled the claimant's reservation of the unit, retaining all monies paid. Consequently, the claimant filed a claim alleging breach of contract, seeking damages, compensation, restitution, interest costs, and other equitable relief. In his judgment, Judge Al Nasser confirms that Article 86 of the DIFC contract law may also be used to assess whether there has been a material breach or fundamental non-performance of a contract. When it comes to the medical evaluation, Clause 5.2 of the agreement in the present case stipulates that the passenger is required, to the best of their knowledge and belief, to declare during the medical evaluation any medical conditions that may affect their fitness to participate in the space flight. Clause 5.3 further reiterates the point that the passenger need only declare a medical condition or symptom that they believe, to the best of their knowledge and belief, would affect their fitness to participate in the spaceflight. But regarding the disclosure of such changes that occur between the time of the initial medical evaluation and the scheduled launch date. The claimant, who suffers from chronic headaches, did not mention this condition during the medical evaluation, as they have been a recurring phenomenon for the past 5 years. Since this was
But
not
Counsel, I just have one question for you. I understand that. I understand that claimant did not disclose as it should have the chronic headaches. But please tell me what is the relevance of that non-disclosure to the present case?
Your Honor, I contend that there has not been a non-disclosure, as that the non-disclosure is not a fundamental non-performance under the contract, because.
Okay.
Yeah.
I'm sorry. Please continue. Please continue.
Okay, thank you, Your Honor. Since it is a recurring phenomenon for the past 5 years, it was not uncommon for her, so she did not disclose the information during the medical evaluations, as she had genuinely believed that the condition would not affect her ability to participate in the retreat and
No,
its
but that is not the case, right? The compromise expressly states, Counsel, that she did not disclose this information because of the same fears that she have had of ineligibility. And this was particularly at the time of the pre-medical test before the PCR test, where she concealed this information, and as a result of which it could have potentially impacted the results of the test, unless you want to dispute that point.
Your Honor, I understand your point, but it must also be considered that the claimant had made a very significant investment of $7.5 million to the spaceflight retreat. And coming back, when we consider the sales representative and his representation of the contract and his advertisement that the spaceflight retreat would provide a means for her to enhance her life force through yogic activities in space. He had also implied that she would not be unable to.
Counsel, please answer my one query. Uh, Under the contract, as per the terms of the contract, or say even otherwise, am I required to pay attention to anything which the sales representative may or may not have represented to the claimant?
Your Honor, I contend that the claimant had acted based on the sales representative's representation. So that is the reason that she did not disclose her headaches, and that is also the reason that she cannot have breached the contract.
But I'll just direct you to 9.1 of the contract agreement. This agreement constitutes the entire understanding between the parties considering the subject matter hereof, and supersedes all prior and contemporaneous agreements, oral or written, between parties relating thereto. So, in view of this clause, am I required to look at any representations made by the sales representative?
Well, yes, Your Honor, because the client here is the client here is a consumer to the contract. So she does not have she does not have any she does not have any legal or business knowledge of contractual clauses or space flight activities. So her agreement to the contract is solely based on the sales representative's representation. So it must be considered.
But are we saying that the contract which she entered into, that there was no ad item because of lack of knowledge
I'm
of
so
the
sorry,
terms
Your
of the
Honor.
contract?
Could you repeat the question, Your Honor?
Are we saying that there was no ad item because of there being no knowledge about the terms of the contract? Is that the case?
No, not at all, Your Honor. I contend that the claimant was very well aware of the terms of the contract and has acted within the contractual terms.
Okay, please proceed. Proceed.
Thank you, Your Honor. Since this was not uncommon for her, she did not disclose the information during the evaluations, as she genuinely believed it would not affect her ability to participate in the retreat and its activities, as she has been able to successfully travel to many exotic locations and perform yoga and meditation without it affecting her fitness to perform any of those activities. Since the claimant could safely take potentially long flights to such exotic places, she had reason to hold the belief, to the best of her knowledge, that her headaches would not affect her fitness to participate in the spaceflight, and thus there was no obligation on her to disclose them. Furthermore, applying Article 86, her non-disclosure does not deprive the defendant of anything they were entitled to expect under the contract, as her headaches were not debilitating to her fitness, and so cannot be contractually required of the claimant to disclose. Moreover, the claimant cannot have been required to disclose her headaches, as it was not quintessential or of the essence to the agreement, as she could have carried out in her participation in the spaceflight and its activities, despite her headaches, as it is a normal, everyday occurrence for her that is more of a minor inconvenience than a debilitatingly weakening condition that would make her unfit for participation. Additionally, since there was no duty to disclose her headaches under the agreement, she cannot have been reckless or intentional, as she genuinely believed it would not affect her fitness to participate, and it cannot be said that led the defendant to reasonably believe that they cannot rely on the claimant's future performance, as she acted honestly and reasonably to the best of her knowledge and in good faith. To conclude my first submission, Your Honors, the claimant has not breached the contract by not disclosing her headaches, as she acted within the terms of the agreement to the best of her knowledge, as was required of her contractually. Your Honors, if I may move to my second submission. I submit that the claimant cannot be held liable for breach of contract, as the claimant's non-disclosure was done not only relying on the defendant's misrepresentation, but also because she had already made a significant investment that she would be unable to recuperate. I would like to direct Your Honor's attention to the case of Salim Douala and Damac Park Towers
Sorry, could you
Company.
just repeat that second submission?
Sorry, Your Honor. I submit that the claimant cannot be held liable for breach of contract, as the claimant's non-disclosure was done not only relying on the defendant's misrepresentation, but also because she had already made a significant investment that she would be unable to recuperate. I would like to direct Your Honor's attention to the case of Salim Douala and Damac Park Towers Company Limited of 2018 from the DIFC Court of First Instance's 83rd judgment of 2021. Would Your Honors benefit from the facts of the case?
Briefly, if you could just sum very briefly.
In this case, Mr. Douala entered into a sale and purchase agreement with Damac to purchase a unit in Park Towers. He alleges that Damac misled him regarding the readiness of the development, and despite paying the full price by July 2011, he hadn't completed the purchase and seek to rescind the contract, and he claimed for breach of contract, which was struck out by the court as statute barred, but his claim for misrepresentation was upheld. The SPA was offered to Mr. Douala after a proposed purchase of a unit in Damac Heights was disrupted in 2008. And Mr. Douala contended in the case that he was assured Park Towers was near completion with specific unit details, leading him to enter into the SPA. The case defines misrepresentation as a party to a contract, making an incorrect statement of fact to the other in order to induce them into agreeing with their particular terms, and which did, in effect, induce the second party to agree to those terms and suffer a loss as a result. Such a misrepresentation can be implied by one's conduct, slogan, or advertising method. In this case, the claimant cannot be held liable for breach of contract, as she agreed to the contract relying on the defendant's misrepresentation that the retreat would give them the opportunity to draw upon the energies of space and enhance their life force. The claimant thus did not mention her headaches because she relied on this misrepresentation made by the defendant's sales representative in the hopes that it would cure her headaches. This was further
Ask a question.
Yes, please.
Why does that representation absolve the claimant of her responsibility to disclose?
Your Honor, I contend that the claimant had relied on this misrepresentation and entered into the contract because she believed that she could cure her headaches by participating in the spaceflight, as the sales representative made no mention that she could not achieve her objective, and she did not disclose her headaches relying on that representation. And also because she had the reasonable fear that if she did, she would due to the inequality of bargaining power in the contract, she would suffer the loss of 7.5 million US dollars.
Okay.
Yeah, just a question, counsel. So, under the laws of obligations, wasn't it misrepresentation for her to omit such information when it directly influences the whole risk aspect of the case?
Your Honor, I contend that there was no risk in her not disclosing her headaches, as there was nothing to there's nothing in the facts to lead us to believe that her headaches would have been debilitating to her fitness or would have been a risk to the other participant or the crew members of the spaceflight, as it is not. As it's been a recurring her chronic headaches have not been an underlying symptom of any condition that has been medically recognized. So there was no way to foreseeably know that her headaches would have put other participants of the spaceflight at risk. So it cannot be said that she had acted against the law.
Yeah, but omitting such information is not misrepresentation. Is that your stand? Just confirming.
Yes, Your Honor.
Okay, thank you.
If I may continue with my submissions, Your Honor.
Yes, please do.
The claimant did not mention her headaches because she relied on this misrepresentation, and this was further reinforced by the fact that the sales representative did not suggest that the claimant would be unable to cure her headaches, through the retreat sessions, and it was implied by them that she could achieve her objective, coupled with the defendant advertising the retreat as a once-in-a-lifetime yogic experience to draw upon the energies of space and enhance their life force. And since she was not advised against participating in the retreat due to her headaches, the claimant cannot have breached the contract, as she acted on the defendant's misrepresentation that she could participate in the retreat to cure her headaches. Relying on this misrepresentation, she entered the contract on the defendant's terms and suffered a loss as a result, as she did not receive what she had paid for from the defendant. The inequality of bargaining power shared by the parties to the contract is evident under Clause 3.1 of the agreement, which states that a passenger who cancels their flight will not be reimbursed for any payments they have already made. Given the significant investment of 7.5 million US dollars she had already made, she suffered from a massive loss, as she could not participate in the spaceflight activities. To conclude my second submission, Your Honors, the claimant has not breached.
Counsel, just one question. Is it your contention that there was an unequal bargaining power in this particular contract, which is a contract for space tourism, where one of the companies is providing you services, and due to the nature of the services, the values are high? Are we contending unconscionability in any manner in this particular case?
Yes, Your Honor, because as I've mentioned, according to Clause 3.1 of the agreement, if a passenger decides to cancel their flight, they will not be reimbursed for any of the payments that they have already made. However, under Clause 3.2 of the agreement, the spaceflight operator has the right to cancel or reschedule the spaceflight while not suffering any loss as a result.
Okay, let us for a second assume that the contract was unconscionable, although it is a service, luxury service provided. But let us assume that the contract was unconscionable. What is your contention with respect to that? What does that achieve?
Could you repeat your question, Your Honor?
Let us assume that there was a presence of unequal bargaining powers in this present arrangement. What does that achieve in relation to your present argument?
Your Honor, I contend that due to the unequal bargaining powers in the contract, there cannot have been a breach of contract because the claimant was a mere consumer to the contract, so she would not have had the same market knowledge or information as the defendant in this case. So they would have had the upper hand, as clearly as can be clearly seen under clause 3.1 and 3.2
Okay.
of the contract.
Okay, proceed. Thank you.
Okay, thank you, Your Honor. Yeah, to conclude my second submission, the claimant has not breached the contract as her non-disclosure was done relying on the defendant's misrepresentation, suffering a loss as a result. Your Honors, if I may move to my third submission.
Sorry, counsel, your time is up.
Okay, to conclude my submissions, Your Honor, for these reasons and the ones stated by my learned senior, I urge the court to find in favor of the claimant, Ms. Artemis Ashrafia. If Your Honors have no further questions, that concludes my submission for the second issue in the proceedings.
Thank you, counsel. Let's move to the rebuttals if there are no more questions from my other judges. So let's move to junior defendant. Rebuttal, please. Junior defendant?
Am I audible?
Yes, you are.
Okay, Your esteemed court, I have 3 questions to ask. May I pursue my questions, please?
Proceed.
The first question is, what accountability does Artemis hold for the financial losses and reputational harm suffered by Solar Dream due to her actions? And did Artemis actually comply with the medical evaluation requirements and disclose any relevant medical conditions as per the agreement? And did you have a clear understanding of the medical disclosure obligations outlined in the agreement, particularly in clause number 5? Thank you. That is all.
Thank you, counsel. Let's move to the sub-rebuttal by junior claimant.
Thank you, Your Honors. Regarding Artemis's accountability for Solar Dream's reputational loss, I contend that she held the right to document and publish her experience. If I may direct the court to, one second, Your Honors, if I may direct the court to the case of Arkham Capital Limited and Dubai Financial Services Authority. Would Your Honors benefit from a brief summary of the facts?
Just the legal principle, please. Thank you.
Okay, Your Honor. According to the case, it was stated that for a business to prove it suffered commercial reputational damage to a statement made by another party to a contract, there must be a contractual reliance on that party not to disclose the information that can cause it reputational harm. And the harm must also be properly weighed against what would be caused to a company's legitimate business interests if the statements were heard in public against the public interest. And another case, the case of Amira Seafoods and IDBI Bank Limited, affirmed that to claim for damages, for commercial reputational damage, the reputational harm must have had a negative effect on the company's business and trading. In this case, there's nothing to suggest that Artemis was the cause of the commercial. Artemis had a duty of confidentiality to not document and publish her experience, as there was no contractual, there was nothing stated in the contract or implied by the agreement that she had to keep confidential her experience. And moreover, it was in the public interest to know what a big company like Solar Dream, who caters to individuals interested in commercial spaceflight, it was in the public interest to know whether Solar Dream, a commercial spaceflight operator, implemented necessary safety protocols, as they have a duty to ensure that their services catering to the public ensure that they value human life and are up to industrial standards to provide the services their passengers pay for effectively. And coming to the second point raised by the junior defendant, there was no breach of contract by the claimant for not disclosing her headaches, as she had reason, as there was nothing to suggest that her headaches would have affected her fitness to participate in the space flight. So there was neither a contractual obligation nor a breach of contract. And that concludes my rebuttals.
Thank you, counsels. Are there any questions from the judges? If there are none, let's just proceed towards the feedback, and then we will be scoring the score sheets. Yes. So let's begin with Aditya, if he can give the feedback. Starting with, I think, Middlesex University one.
Yeah, so I think I'll start with this is, Ryan. Please correct me if I'm pronouncing your name wrong. Uh, Very good organization and structure. You spoke in a composed manner. There was a good use of facts and legal principles. Otherwise, also you maintained the flow while providing us a very crisp structure. My suggestion to you would be perhaps more emphasis on drawing the judge's attentions to the compromise, taking them to specific clauses and reading out and emphasizing particular lines from those clauses. With respect to a second point of feedback that I would give you is whenever, say, I'm asking you a question or any judge is asking you a question on any particular thing, the way to respond to it is that you answer it briefly so that the query is closed, and if it is covered in your later submission, or if your junior counsel is covering, you just say that it will be explained further in detail by my senior or my junior counsel. Otherwise, great work, and yeah, that's about it. For Then comes Sarah, the junior counsel for the claimant. Again, same feedback, good presentation. With regards to the questions, I think you just again have a lookout for all the contractual clauses which are there. Just go through the agreement and uh, just make sure that it's logically flowing, the arguments. If you're calling it unconscionable, for what reason? Always question why. But otherwise, good work, you guys. So that is it for the junior council. And now we come to the defendants team, which is we start with Hessa and then Hin. Hessa, again, you spoke well, and the structure was there. The good part was that you were also quick on your feet to respond to questions. But just have some questions sort of in mind, the common questions which would be asked, especially from the defendant side, considering how exactly are you claiming what you're claiming, and this is just sort of a flow to that. But apart from that, I think everything was good. More emphasis can be brought on contractual terms. Again, refer the judge to the relevant part of the compromise. Be clear about which obligations arise out of the law of obligations and which out of the contract. So yeah, I mean, and that's for Hessa and Hind. I think just generally whenever you're speaking, modulate it a bit more, make it more engaging. See if the judges are engaged. Look at their reactions to how your arguments are proceeding. Because the point should again not be to just conclude with the arguments, but making it in a way convincing for the judges. Slow down your pace a bit so that it's not going in a monotonous tone, but everyone is engaged. And as a general feedback for all of you, I think the best rounds that happen in general rounds, or I would say even in general, if you're going in any hearing or arguments, the best way to go about it is to make it engaging, because then the judges understand, read, engage, and are involved. But all of you guys all have done a great work. It was a great quality round, and that sort of concludes the feedback from my end. And I think Karim is there. I think Karim left the meeting.
Yeah, I'm here.
Okay, Karim is here, but then Ikra left the meeting.
No, I'm here too. This is some issue, yeah. Kareem, you can go
Yeah.
next.
Thank you very much. I just have a few comments. I echo everything Aditya said. I think I very much agree with his assessment. I just have a few things to add. Starting with the senior counsel for the claimant. I would say just speak a little bit slower. I got the sense that you were reading from a paper and it wasn't very engaging. You have to keep in mind that for judges, you might be very passionate about your submissions. But for judges, it's their job, and they're there for long hours every day. And the last thing they want is to go into a hearing and have someone reading from a piece of paper very quickly and they can't follow it. So speak a little bit slower, make the speech a little bit more engaging, and to the extent that you can use documents, echoing what Aditya said, use documents, highlight specific phrases, specific phrases in the evidence, specific clauses in the contract, specific articles of law that you really want to imprint in the judge's mind, and make those stand out in your speech, so that you're really allowing the judge to keep that point in his mind as you go through your submissions. But generally, very good round. From the senior claimant. For the junior claimant, I thought your presentation was good and structured. I think one thing I would add is, if you can focus on submission that you make, if you can clearly set out to the court what it is, what the proposition is that you're making, and what the law is, in summary, in very clear term, what the law is in relation to that proposition, and what the court has to find in order to agree with that proposition. So if you set those out, for example, in relation to negligence, my argument is one. In order to find for me, the law states that the court should find A, B, C. And if you set those out before you go into your submissions, then the court can follow you in relation. It can be more structured in that way. But again, junior claimant, very good round. Thank you very much. Senior defendant, I also have a note. I've taken a note here to also speak a little bit slower, and to make the speech more engaging. For the speech, the speech should not come off as being read from a paper, in order to keep the judges engaged. And also, I have written here, use the documents and take the court to the relevant pages. Thank you, senior defendant. Junior defendant. Echoing again what I said for the junior claimant, if you can have more structure in the speech, it would be easier for the court to follow you on your submissions, and to follow your argument, and to ultimately what you want for the court to agree with you and to find in your favor. The easier you make it for the court to follow your argument, the easier, the more likelihood you have to convince the court of your arguments. In relation to your submissions in rebuttal, the last submissions you made, I think we judges, maybe we should have pointed this out, but it's generally speaking, it's not for the junior defendant to, or the junior counsel to, or senior counsel, any counsel for that matter, to be asking questions. It's for the judges to be inquisitive, to ask questions to the claimant and the defendant. The counsel should not be asking questions to the other party. If you have submissions to make, which allow the court to draw similar conclusions to those that you want the court to draw as a result of the questions that you're asking, then just make those submissions rather than asking questions of the other side. Um, that is my feedback, and thank you very much all. I agree with Aditya. It's a very good round, and thank you for your effort.
Yes, thank you, Kareem. And I think I agree with Aditya and Kareem as well. Both teams were really good. That's what I've gotten from it. Especially, what I'm going to say is with the speaking fast thing, I have the same problem, and I had to like bring it down a bit, and that happens when you're reading it off from your speeches. So I always recommend to never write your speeches word to word. Always go by points. So that's one of my suggestions. Just if that would help in your future rounds to slow down a bit. If you go by points, you already know what you're making, what submissions you're making because you have revised this like I don't know so many times before you came into this round, right? So once you start making points and okay, I'm going to say this submission now and then this, if it's making sense in your head, automatically you're going to say it the way it is. That's one of my suggestions when it comes to speaking fast. And it will really help you build the argument, structure it properly, and make it make sense. One of the things I think which was lacking from the University of Sharjah side, I'm so sorry about that, was the the structure itself. So with mooting, you need to follow a certain code ethic and how you address your honors and all of that. So that was a bit not there. So that's what I would expect, like more formality, more how you're supposed to address and satisfy the code ethics, because that's something which is very basic. So that's supposed to be there. That's something which is expected of the judges. And the other thing would be yeah, again, the questions part. So sorry we didn't point it out while the submissions were going on, but yeah, you're not allowed to really question the other side. What you can do is, of course, rebuttal is basically punching on the thing which is your strongest point and which lacked uh, in the other council's point, so it wasn't there. So that's what you do. So what I would recommend is just yeah, make a submission which is strong, to the point, and makes sense. Don't try to overload it with too many things, and I think it will make more sense that way. And rebuttals don't even need to be that long. It can be just like 1 to 2 sentences, but as long as they're strong, that's what matters. So yeah, that's pretty much it. Thank you so much for a very great round. And since there were no technical difficulties to this, today it actually felt so good to hear both parties, nicely and engagingly. So yeah, that's my recommendation. Thank you so much. So now we will be just moving forward to scoring. The judges will be scoring now on in the judges room. You all are free to leave. Thank you so much. Thank you.
Thank you so much. Have a nice day,
Thank you.
everyone.
Yeah, good
Have a
luck. Good
nice
luck
day.
with your other rounds. Yeah.
Same issue. I do not have the link to the judges' room.
Okay, let's just ask
Yeah,
the
participants, please can please exit, and we will just have
yeah.
to make do with this room. There's some technical issue on my end. I think it's my firm's firewall which is blocking the entry into the site.
Makes sense. Let's just wait. There are just a few
Yes,
still in the room.
yes.
So
Judges, I'll also drop off then.
yes,
Yes,
please.
please.
Thank you.
So there's just sheer left. There we go.
Yes. Yeah.
All right.
Yeah. Hi. So I'll just Ikra and I, we judged around yesterday, so we haven't introduced. I'll just introduce myself. I'm Aditya Singh Chauhan. I'm working out of a law firm in Mumbai in India. It's called Khaitan and Company. We do my team specifically does construction, all the way from drafting of the contracts till the end of the dispute. With my specialization being arbitration. And I also do related hospitality work. And yeah, I mean, I have a close connection to Dubai. Long back, I think in 2019, I'd interned for 3-4 months in Al Tamimi. So that is how
Okay.
I'm sort of was still involved in all the DIFC related things. So it was fascinating seeing the law of obligations, which I did not at the time of my internship. Uh,
Yes.
Primarily dealing with arbitration at that time. So yeah, I mean that's from my end.
Excellent. Yeah, very nice to meet you. My name is Kareem. I'm at Tamimi, so I don't know if we would have.
Oh, that's
Uh,
wonderful. Which it's the DIFC team.
yeah, I'm in the international litigation group, so we do DIFC, ADGM, and some other common law courts in the region.
So in Tamimi, there's the commercial litigation team, which is on the floor above, and I think on the floor below, the fourth floor, if I remember it right, is the international arbitration team. And
That's correct. Yeah,
previously, the team was run by Thomas Snyder, who has now moved to Charles Russell's.
that's
So
correct.
that was the time when I had interned over there. But since I think the entire team, and I mean the entire team, has left.
Yes, that's right. Yeah, we've now moved buildings as well, so we're now in Central Park Towers,
Hmm.
a little bit down the road, and the arbitration and international litigation teams have merged under one roof. So some yeah, quite changes. But I do remember that old building you're talking about, and I quite miss it actually. I think it was a much
It was
better
wonderful.
location for a new building. Yeah,
It was a wonderful building.
yeah. Very nice to meet you.
Nice to meet you. Nice to meet you.
So how does this work? How do we go about judging these?
Yes, so I think we just need to. So there's supposed to be just one score sheet, and we just score on that, depending on senior counsel and junior counsel per claimant and defendant. So that's pretty much it.
So I think last time Ikra had taken care of it. We just discussed and we finalized this course. I'll just tell you what I marked for senior and junior consuls in this particular round. So for the first three categories for the Middlesex University of Dubai, and again, this is a liberal marking. I have given them 8.5 for both junior and senior counsels. For persuasiveness, the senior counsel I have given 8, and the junior counsel I've given 7. And for presentation and teamwork, I've given them both 7.5. With respect to the defendants, I have for the first two criteria, both senior and junior counsel, a consistent 6. Use of authorities and citations. To the senior one, I've given 5, and to the junior one, I've given 6. Persuasiveness and reasoning, to the senior, I've given 6. To the junior, I've given 5. And presentation and teamwork, to the senior, I've given 6, and to the junior, I've given 5.
Okay.
Yeah, I mean, I'm very happy for you to include the same marks that Aditya just gave for my own. Very happy with that.
Okay. Perfect. So other than just confirming, you said 8.5 for the first three criterias.
Yes, yeah, I think we can just one by one go and just give the final one. So organizing structure, claimant 8.5, senior counsel, claimant 8.5, junior counsel.
Okay, both 8.5,
Yes.
8.5. Okay, and the
Uh,
defendants?
6 are both consistently.
Okay.
And the same follows for the second column also. The use of facts and legal principles.
Do you have a specific feedback
Uh,
towards the claimant?
Specific feedback towards the claimant.
Yeah,
They
defendant.
did a
I have.
pretty good job. I think what was lacking is essentially just drawing a connection from when they start the argument till the end. So when they had first started out, they were talking about a few things, and I think uh, one question I'd asked.
yeah, I would agree with that. I think just I mean their submissions were good. They would be better if they had the legal principles down for each argument they're making,
Yes. Yeah.
and they said it very clearly at the beginning of their submissions, and then they took the court through each one of those criteria one by one.
Yeah.
That would elevate their submissions to another level.
So I think, for example, unconscionability, they mentioned unequal bargaining power. It had no role to play at all. Then later on, she mentioned that they have specific expertise with respect to space tourism. That was relevant, but that was not unconscionability. So that point didn't make sense with respect to her argument. This was the junior counsel, and then she had also mentioned about the various representations made by the sales representative. And
Yes.
later on, I had pointed her out to the entire agreement clause, and she got stuck with it, and she could not argue, which is why I marked one down on persuasiveness, and then she should have already known to the clause. And the other side, in the rebuttals, they should have bought it or forward the other side completely missed the mark.
Wisdom.
So
Yeah. Yeah. Okay, so the use of authorities have the same marks, right? 8.5.
8.5, 8.5 for the claimants. For the defendants, it's 5 and a 6. 5 for the senior, 6 for the junior.
Okay, got it. And the persuasiveness, the senior counsel for Middlesex would be 7, right? You said?
Persuasiveness, okay, it's
Oh no, for
7.5 and 7. Just make it 7.5 and 7.
okay, 7.5 and 7. And what about the defendants?
It's a 6 and a 5. 6 for the senior, 5 for the junior. Because I think the junior counsel was she did not even at all read the room. She just went on in one flow. I believe she did not receive a single question throughout her speech.
Yeah, because her speech was very short. She didn't even address any of the
Hmm.
things by the by the other.
For teamwork and presentation, 7.5 and 7.5 to the Middlesex team, and to the defendants, it'll be a 6 and a 5.
Okay. And can you just so should I just mention all the comments we have for the defendants? Like they have a lot to improve. So
I mean, politely. I'm not sure how
yeah,
they're going to use it. Are they going to send it? And we want to be motivating
yeah.
as well.
Okay.
So I'm not sure. I'm not sure how to address the comments. I mean, and okay, we can let the comments be for now because I don't want them to read something and be disheartened. The point of the moot is to motivate the young students to sort of,
Exactly. I don't think so. They will be getting this
yes,
like
and the
before.
verbal feedback we've already given. So
Yeah, I think that's perfect. Okay.
yeah,
Yeah, I'll just total and then send it to
yeah,
them. Is there anything else?
no, that's all.
Okay.
Again, amazing judging another round with you, Ikra, and amazing meeting you for the first time, Kareem. I'll be in Dubai. I'll be in Dubai in this November for the Dubai Arbitration Week. So
Okay.
Nice.
hopefully we'll meet over there.
Yeah, please come to some events at Tamimi, and I'll
Absolutely,
make sure to keep an eye out for you.
Yeah.
absolutely.
Thank you.
Okay.
See
It
you.
was
See
very
you.
nice meeting you all. Thank you.
Very
Nice
nice.
meeting you.
Take care.
Bye.